There are over 20 different kinds of temporary visa categories, also known as non-immigrant visa categories. They're known by their letters and their numbers because that's where they're located in the immigration statute. These visa categories go all the way from A for ambassador down to W. And we immigration lawyers try to remember them by acronyms. So the S visa category, for example, I call the sneaky snitches because you can actually get a visa if you're coming into the United States to rat on some organized crime figure. Some of these visa categories also have green card analogs, so it's easy to transition from one temporary visa to a green card. Others don't have an easy transition. Some of the temporary work visa categories allow you to work easily in the United States, like H-1B. Others are for study, like the F-1. Others are for visitors, like the B-2. Most of the categories are for a single purpose, but some categories, like the F-1 for students, have a main purpose, like studying, but they do also allow the person to work under certain conditions. Each temporary work visa category has differing validity periods. For example, usually you're limited to 6 months for a tourist, but you can be in the United States for up to 6 years or even longer if you're here on an H-1B work visa. Each category has different eligibility requirements. So, for example, if you want to get an H-1B work visa, you have to have a bachelor's degree or equivalent. But an H-2B for other temporary workers does not require a college degree. Some categories require an employer to sponsor the foreign national, like in the H-1B area. Other categories do not require an employer sponsor. For example, if you're a temporary visitor for business, known as a B-1, you can come in without an employer sponsoring you. Some work visa categories require an employer to first test the U.S. labor market to make sure there are no U.S. workers before they can hire a foreign national. The H-2B for certain temporary foreign workers is one of those examples. Other categories don't require a labor market test. For example, L-1, intra-company transferees of managers or executives. The H-1B visa category has something in the middle, an attestation on paper by the employer that they will pay the H-1B worker their required wage, but not a full-blown labor market test before they file the petition. Some categories require a petition to be filed and approved first by the U.S. Citizenship and Immigration Services, also known as USCIS, before the person can go to a U.S. consulate overseas to apply for a visa or before they can change status in the United States. The H-1B category is an example of that. But other categories don't require that petition first. For example, you can come into the United States from certain countries for up to 90 days without any visa. We call that the Visa Waiver Program. Similarly, if you are an E-2 treaty investor, you don't have to file a petition first with USCIS. You can file directly with the U.S. Embassy or consulate.